terribly interesting or sexy, to be sure. But the fact is that over the years that I've worked with the Office of Attorney Regulation Counsel, we've seen many, many sad situations caused by file retention and file delivery, mishandling by lawyers not really understanding what their duties are. And so while it may not be a sexy topic, it's certainly a hot one, and one that's even made more important by the passage of a new rule this year by the Supreme Court that gives lawyers some real clear guidance as to how long they must retain files or under what circumstances they may destroy files. So, before we get to that rule, it's important to consider why even maintain a file. After all, no rule of professional conduct requires you to maintain a client file, but I couldn't imagine working as a lawyer or discharging my professional duties without a client file. And certainly, no rule of professional conduct tells you what form that client file must take, what's got to be in it, what sub-files, whether you open up files by matter, by client. But you've got to remember, as an attorney, as a professional, you've got certain duties to discharge. Duties of competence, diligence, loyalty, communication, and confidentiality. And to discharge those duties, creating and managing files properly is essential. And so again, I get back to my theme. It may not be sexy, but the failure to handle client files properly can lead to serious negative results. Once you've created the client file, the question arises, what's my obligation to return it? And the obligation to return the file occurs when you terminate the client relationship, the attorney-client relationship. An attorney-client relationship is based on the subjective belief of the client. If a client says, I believed that Attorney Jones was representing me, and if that client's belief is based on reasonable objective criteria, then there's an attorney-client relationship. If the client says, I believe Attorney Jones was representing me because I dreamed last night that Attorney Jones was my lawyer, not an attorney-client relationship. No reasonable objective criteria support the client's perception. But assuming you've established an attorney-client relationship, how do you terminate it? Again, no rule requires it, but I strongly suggest that you write the client a letter. You let them know that our relationship has ended. This way, it would be difficult for a client to say that I still thought that Attorney Jones was representing me in the face of having received a letter. If you send the client a letter or you terminate the attorney-client relationship, what do you do with the client file? Ideally, you return the file to the client. But we all know, as practitioners, this doesn't happen. It rarely happens. After 11 years in the Office of Attorney Regulation Counsel, I've just this year destroyed my final box of client files and managed to park my car in my garage. Clients don't want their files back, and it leaves to you the obligation to store them. You can store client files in a paper format. You can store client files in a scanned electronic format. But be careful. If you choose to scan client files, remember, first of all, that technology changes. And the technology you use to scan a client file today may not be around in 5 or 6 or 8 years when you want to access that file. So be careful to use technology that you can update or that you think you'll be able to access. You can also store client files in the cloud. But there again, there may be security issues, privacy issues related to using the cloud. Clients may not be comfortable with that. You've got a duty to retain your client files unless they take them back. We have this new rule, 1.16a, that talks about the duty to retain files and says when you may destroy client files. This is a breakthrough because, as I say, it gives lawyers black letter law as to when they may destroy client files. If the client takes the file, great. If not, if the client signs a writing saying that they are okay with your destruction of the file, that's great. In the absence of either of those two circumstances, you may send the client a letter saying that you'll destroy the file no fewer than 30 days from the date of the letter. And after the 30 days elapse, you may destroy the file. Finally, under our new rule, after 10 years have elapsed, you may destroy the file without notice to the client. But understand, in any of these circumstances, there are exceptions. You can't destroy any document that another law requires you to keep. And you can't destroy any document that you know relates to threatened or pending litigation. Finally, you should be careful and probably not destroy any document, any original marital agreement, will, deed, bond certificate, or document of that nature.